Todd Halleck here today, talking to you about a planning technique that we use quite commonly. It's an intra-family loan, meaning it's a loan from one family member to another family member. These can be a great way to transfer family businesses, to transfer wealth from one generation to the next, and to freeze the value of an estate so it doesn't exceed the estate tax exemption limits. But as with any planning technique, it's important to pay attention to the details and make sure that you're actually creating a loan as opposed to a gift, because there's very different consequences from a tax standpoint to a gift versus a loan. So what are some of the things that you should be doing if you want to make sure that you've structured a loan properly, an intra-family loan properly? Well, recently the courts have expressed what we should be doing to make sure that we truly have a loan. The first thing that they'll look at, or one of the first things they'll look at, is, was there actually a promissory note, right? If you're going to loan money to a third party, you're almost certainly going to have a written promissory note evidencing that debt. And when you're doing an intra-family loan, you also want to have a written promissory note that actually will express what that debt is and what the terms are. Second thing that they'll look at is, was there interest being charged? It would be rare to loan money to someone and not expect to receive that money back with interest. And so if it's truly a loan and not a gift, the court is going to expect that you're receiving interest as well. In fact, there's a thing called the applicable federal rate, which is the lowest amount of interest that can be charged by law on a loan. And that's set monthly by the IRS. If you charge less than that, interest is going to be imputed to you. So your intra-family loan should have interest charged. Was there security for the loan? You're not going to loan someone $7 million and they're not going to have some sort of adequate security. You're not even going to loan someone probably $100,000 and not have adequate security to get that money back. So you want to look at, how do we collateralize that loan to make it look like truly a loan? Was there a fixed maturity date, right? If it's just this can get paid whenever I call it due, that starts to look more and more like a gift, as opposed to, this loan is due in 3 years, 5 years, 15 years, whatever term you set within some level of reasonableness. I generally don't like to go beyond 30 years because you're not going to find many loans out there commercially available beyond 30 years. So is there a fixed maturity date? Was demand for repayment ever made, or was it always ignored? Again, you need to treat this like it's a true loan. And so if it's not been paid, you need to make demand for that repayment. And attached to that, number 6, was actual repayment made? Was there ever a repayment that was made to the lender? 8th, were records maintained? If you loan somebody money, you're usually going to keep some sort of a ledger to reflect whether or not you've been paid and when and how much and all those things. So keeping, as so often is the case, keeping good records is really important. Did the person that you've loaned the money to have the ability to repay the loan? Sometimes we set up what we call sales to irrevocable grantor trusts. And one of the key things that we do in establishing those irrevocable grantor trusts is seed it with enough other assets by way of gift to make the loan transaction more commercially reasonable. If I don't have a dime to my name, you're not going to loan me any money. You're going to want to know that I have the ability to repay that loan. And finally, how was the transaction reported for tax purposes? Was it reported consistent with a loan? When you received payments in, did you pick those up as interest income on your tax return? So you want to, A, pay attention to the details, B, keep accurate records, and C, be consistent in how you're treating that across the board. The court's going to look at this holistically. These are not a list of items that if you do this in every case that you'll absolutely get treatment as a loan versus a gift, but they are going to provide the framework to show that the more of these you're doing, the more likely it is to really be a loan and thus be treated that way for tax purposes and for other legal purposes. So an intra-family loan is a great way of planning, freezing estate values, moving assets from one generation to the next. But as always, you got to do it right or don't do it at all. So I hope this has been helpful to you. We'll see you next time.